Hello, everyone. Today, we are having a discussion on the Supreme Court judgment, which has upheld the reservation for economically weaker sections. We are joined by renowned academician, Dr. Mohan Gopal, who had appeared for one of the petitioners in the case, opposing the 103rd Constitution Amendment. Welcome, sir. Thank you so much for joining us.
Thank you very much, Mr. Sebastian.
Thank you, sir. So we'll be listening to the views of Dr. Mohan Gopal regarding the Supreme Court's verdict, which has upheld the EWS quota by a majority of 3:2. So, sir, one of the major takeaways of the judgment is that the court has held that reservation can be granted on the sole criteria of economic status. Even the minority judgment has broadly accepted that economic criteria can be a singular ground for granting affirmative action to an extent. So one of the petitioner's arguments in the Supreme Court was that reservation is a tool for representation of classes which are facing social backwardness due to various factors. So it is to correct the historic injustice that reservation has been granted. And reservation is not a program for poverty eradication. So economic status is a person's individual status, and that is a flexible status. It can change anytime. On the other hand, one's backwardness due to a caste identity, that is something which is immutable, even if a person attains economic growth. So this was one major argument raised by the petitioners. But the Supreme Court has held that granting reservation on the sole ground of economic status, that is not violative of the basic structure of the Constitution. So how do you think the Supreme Court's judgment has engaged with the arguments of petitioner's side regarding economic criteria?
Thank you, Mr. Sebastian. That's a very good and important question that you've raised. Conceptually, let's begin by understanding. I am one amongst those who strongly made the argument that reservation is only a tool for representation. And reservation is a dangerous tool if it is used beyond that. It should not be allowed to run loose in society because it will eat up equality of opportunity. And so we need to understand the root of this argument. The root of this argument actually comes from the fact that there are only, I believe, 7 or so uses of the word reservation in the Constitution. I'm talking pre-EWS. And all of those in one form or the other are intended to protect representation. So there can be, in addition, if you look at the language in Article 16.4, it's very clear. It says, I'll read, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any, and let's say, and any backward class of citizens. Here we may say in 16.6, economically weaker sections of citizens, which is what it says, which in the opinion of the state is not adequately represented in the services under the state. So 16.4 is very clearly about representation. And 16, the subheading of 16 as a whole is equality of opportunity in matters of public employment. And 16.1 says there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. So it's very clear that the entire purpose of Article 16, of which 16.6 is a part, is to ensure equality of opportunity for all citizens, which means there shall not be discrimination, there shall not be exclusion, right? Then if you look at Article 15, which is the only other relevant part, and they're all part of the equality code in the Constitution under which go from 14, 15, 16, 17, and 18. 15 prohibits discrimination on grounds of religion, race, caste, sex, or place of birth. So no citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to any specified specific areas. 15.1 says state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. So you see the very tight interrelationship between these 15 and 16, and equality before the law says state shall not deny to any person equality before the law, the equal protection of the laws. So equal protection, equality before the law, discrimination, and representation which is prevented by discrimination and lack of equality before the law. Now, no interpretation of any of these provisions can go beyond this framework. So we must understand the proposition that economic criteria can be a basis of reservation as subject to the requirement that that must be for the purposes of addressing inequality in one form or the other. Inequality result discrimination, exclusion, lack of representation, right? So 16 deals with representation in public employment. 15, where also there is a reservation, deals with other forms of discrimination, which also results in exclusion. So representation is basically another word for saying inclusion. Representation is another way of saying there shall not be discrimination. So economic criteria can only address issues of equality because this is part of the inequality because this is part of the equality code. Now, if you take 16, it must be in the context of equality in matters of public employment, and there economic if there is a determination genuinely that economic criteria are resulting in lack of representation of any group in public employment, surely the state can act on that. So there's nothing inconsistent with saying that reservation must be a tool of representation, and that economic criteria can be a basis for intervening where economic criteria result in inadequate representation. Similarly, under 15, where economic criteria are a basis of discrimination and therefore exclusion, again, economic criteria can be used. Now, the second more important or equally important point is that there is a distinction. We have to understand what do we mean by economic. Economic is not financial. Economic is a very broad concept. It looks at the issues of resources. It looks at a very broad set of criteria on which are multidimensional in nature, and you can see that in terms of the definitions of poverty, which is an economic concept. Poverty is not a financial concept. So if you look at multidimensional poverty indicators, which are now accepted by the government, Nyaya and Niti Aayog, and are produced by Oxford University and UNDP, they have a set of multiple criteria, which also include social exclusion and social discrimination. So when we look at economic criteria, we should not mistake it as financial criteria and simply income-based criteria. It's a much broader concept, multidimensional concept, and it then sort of merges with the idea of social and economic backwardness. I'd argue before the court that the relationship between weakness, which is mentioned in Article 46, which is the basis of EWS, weakness is incapacity to resist as a group. That's a requirement on Article 46. Economically and educationally weaker section means that they're, because of economic and educational factors, a group as a group, not individuals. The group, section, a section of the people as a section have no capacity to resist. Backwardness is a result of weakness. Backwardness is a rank. Weakness is a quality. You can be back at the back or in front. So weakness pushes you to the back. So when you say economic criteria, we look ultimately at all the criteria that affects access to resources of people, social resources, financial resources, social capital, financial capital, all these aspects. So I don't think, and that's what we look at in the criterion social and educational backward classes. That's not a caste. Social and educational backward classes can come from any caste, any religion, any region. Transgender is a Supreme Court declared that transgender is a socially and educationally backward class. The National Commission for Backward Classes some time ago said that often should be a backward class, because we are just looking at a combination of social, educational, economic, and political criteria and marginalization to decide which is a backward class. So when we say economic criteria, that is basically another way of saying that there must be a broad multidimensional approach, which is what the criteria are for socially and educationally backward classes and scheduled castes and scheduled tribes. So it's just a different way, I believe, of expressing the same idea. They did not say you can have reservation based on income alone. No judgment said that, and they cannot say that, because income alone can go up if you get a if you get a high-paying job, your income will go up. If you don't, it'll go down. If you win a lottery, your assets may go up, your wealth may go up. And that can never be the basis for assessing economic weakness, educational and economic weakness. Remember also that the government said this comes under EWS. EWS is enacted pursuant to Article 46. And therefore, we have to work within the framework of Article 46, which lays down the criteria of educational and economic weakness. So I don't think there is it is the way you see it, that somehow caste should not be a factor. The second thing is, caste is not a factor for 16.4 and 15.4 reservation. Caste is not a factor. A caste is an eligible group. A religion is an eligible group. A marginalization such as for transgender, prejudice is an eligible group. Once you're a group and you claim that we are marginalized and unrepresented, and you fulfill the secular criteria, all of which have to do with the fact that as a result of marginalization and lack of representation, this group relies as a group, the women, men, and children in that group primarily depend upon stigmatized manual labor as a source of livelihood. That's the essence of the criteria in social and economically backward classes. So it is wrong to say that there is on one hand caste-based reservation and then there is economic reservation. That's completely wrong. It shows a total lack of deliberate, I think, misportrayal of what social and educationally backward class SC/ST reservation is all about. Deliberate distortion of that, and nor is economic criterion simply divorced from the reservation in social and educational backward classes. They're all means of tackling weakness and the backwardness resulting from weakness, regardless of the nature of the weakness or the nature of backwardness. You're pushed to the back of society, and then you require representation to overcome it, because the diagnosis is that at the root cause, these are symptoms, but the root cause of your backwardness and marginalization is that you don't have a seat at the table of power. And if you do, then you'll be able to solve your own problem. It is not a paternalistic view that you are inherently weak, incompetent, incapable, less endowed, less capable, and therefore you can be pulled up. The diagnosis behind the 16.4, 15.4, and 16 and 15 is that it is prejudice and discrimination and exclusion that is the cause of poverty, not lack of capacity on the part of those who are poor.
So you are saying that economic criteria for reservation, that is something which is envisaged within the Constitution itself, provided the economic criteria is resulting in social backwardness, social and educational backwardness, and inadequacy of representation. But the problem with the EWS reservation, the way it has been structured as per the 103rd Amendment, which has been highlighted by the petitioners, is that excludes one section from the EWS quota. That is the people, the sections who are already covered under 15.4 and 16.4, which in
Yes.
common parlance known as the caste-based reservation, that is a CST OBC reservation, they are excluded.
Wrongly known as, because it is not caste-based reservation, as I told you. That's a deliberate distortion, deliberate and dishonest distortion.
Right.
It is not caste. I told you that there are all kinds of religions that have no caste. There are people who have no caste because all these years they were called outcasts, so they have no caste, they can get reservation. Those who have caste, from Brahmin Varna, Vaishya Varna, Kshatriya Varna, they can get reservation. Transgender can get reservation. Orphans can get reservation. So how do you call this caste-based reservation? We should not perpetuate this deliberate distortion. So we can call it for what it is. We can call it reservation for representation, reservation for the unrepresented, reservation for those who are discriminated against, because this is part of a equality clause. This is not part of some other part of the Constitution. It's part of a section of the Constitution that is titled Right to Equality. So those who are suffering from inequality, reservation for them, right? Not caste-based reservation. Yes, sorry to interrupt, but I need to.
I understand.
Make this.
So in fact, even during the arguments, you had said that you had raised this point, and you had even mentioned that in certain states, even persons who are forward castes, they are included under 15.4 because of social and educational backwardness. So, but this is the general perception that I was just addressing that.
But that's a wrong perception perpetuated by the dominant classes.
Right.
Yes.
Even the judgment also uses these terms. That is one.
Yes, of course. Yes, of course. Yes, of course.
The one major flaw highlighted by the petitioners was that the EWS reservation that excludes one section and it confines the benefit only to one particular section.
Yes.
And how do you think the court has justified this?
Well, first of all, we must not forget the fact that although many of us felt that at the beginning that we would get a 5-0 endorsement of the 103rd Amendment, we got a 3-2 result. And the Chief Justice of India, no less, has come to the conclusion that EWS violates the basic structure of the Constitution. That's something we have to take into account very seriously, right? And Justice Ravindra Bhatt, one of the most experienced judges who's written a number of judgments on the constitutional law on reservations, right? And other aspects of constitutional law, and written judgments on the Constitution, deeply understands the Constitution. These two judges have come to the conclusion that EWS violates the basic structure of the Constitution. Now, we can't say Supreme Court has, and yes, 3 judges have said that's not the case. These are not the 3 judges who've had extensive experience in writing judgments on the constitutional law on reservation. But we respect them. They're judges. Their decisions are equally important. We respect and honor that, and we accept that the decision of the bench is to uphold it. We accept that. But we have to understand that the Supreme Court's approach, Supreme Court as a court's approach to this issue is actually much more nuanced and complicated. And that the Chief Justice of India, no less, it's not my view. The Chief Justice of India has taken the view that EWS violates the basic structure of the Constitution, and primarily because of this exclusion, right? So, so that's a serious view, which the majority did not agree with, but it's not something we can dismiss. So, and I would like to think that it is, I compared this case to the ADM Jabalpur case in the opening argument or the opening intervention I made. I said, this is the ADM Jabalpur of social justice, this case, right? So I have no doubt that one day, that was 4-1, this was 3-2. There were two HR Khannas here, not just one. And but I have no doubt in my mind that one day that this will be considered a judgment, that the majority judgment will bring shame to the Supreme Court, and that one day it will be reversed. So just as we have to treat it the way we treated ADM Jabalpur all along, right? We did not take it, we took it as a valid judgment, 4-1 judgment, 4 judges. In that case, unlike here, the 4 judges included some of the most senior judges of the Supreme Court, right? And yet we always understood that it somehow did not reflect the views of many other benches and many other courts. We treat it as valid. We treat it as law of the country. We accept the constitutional validity of EWS amendment. But we must understand that there are 2 very important judgments. There's one judgment of two very experienced judges who, after careful consideration, have said not only that this is unconstitutional, but that it destroys the social fabric of equality. Right? So what we need to do is really more than we can reflect on how the majority judgment deals with this issue. I frankly could not find how it has dealt with that issue. And let me briefly, if you have time, let me briefly address that part of what the issue itself is, right? Now, there are 2 ways in which the issue is presented. One way is to present the issue as having to do with whether you can exclude somebody from reservation because they're covered by other reservations, right? And provide reservations to those who do not have the cover of reservations. Right? This is how it is justified. Now, let's examine that. Right? Those who are provided reservations do not have eligibility for vertical reservations, SC, ST, and OBC reservations, but they have eligibility for several other types of reservations: sportsman reservation, disability reservation, domiciliary reservation. If they're children of officials, they have reservations. There are so many reservations that they're entitled. Isn't that double reservation? So why didn't the amendment say that only those who have no other reservation can get EWS, who are not eligible for, not avail of, those who are not eligible for, because you've said that those who are not availing of, but those who are eligible for SC, ST, OBC reservation are excluded from EWS. Whether they avail of it or not, they don't have an option of asking for EWS reservation. They don't have an option simply because they're born into a family that belongs to a group that is eligible for SCBC, SCST reservation. They're excluded from even applying for or being considered for EWS. But those who are eligible for women's reservation, sportsman reservation, disability reservation, domiciliary reservation, other reservation, they may not avail of it, but they're not excluded from EWS reservation. So we know this is a false argument, that there is the reason is double reservation. So what can be the genuine reason? Why you are picking out SC, not you, people are picking out SC, ST, OBC reservations as caste-based reservation and wrong reservation, and though others must also get the similar kind of reservation. Why this concerted attack on that? Have we heard a serious attack that EWS will reduce merit in public employment or in education? Have we heard a serious argument that sportsman reservation? There are many brilliant sportsmen who are fantastic scholars, but there are also sportsmen who are not fantastic scholars. Will that reservation have a bad impact on public employment or education? That doesn't bother us. It should not bother us, but it doesn't, right? Or women's reservation. So why this attention, this singling out of reservation for SC, ST, OBC for denigration and for saying that, look, somehow it is a danger to merit and so on? Why this discriminatory treatment against SC, ST, OBC reservation? And for that, you'll have to understand, to get an answer to that, you'll have to understand that what's really going on here has nothing to do with poverty or economic weakness. It has to do with the transformation of the Indian state, judiciary and executive, and education as a feeder to the judiciary and executive, to the Indian state, from being controlled by an oligarchy of 2 or 3 or 4 communities, small communities that monopolize the top opportunities in the executive and the judiciary, the most lucrative, the best opportunities where powerful decisions are made. and the transformation of that oligarchic nature of our judiciary and executive to a more representative judiciary and a representative executive by providing representation to those who are unrepresented. So another way of reading the criteria for EWS in 15.6 and 16.6 is to say that it is available for EWS is for sections of the population excluding unrepresented communities and groups. Reservation for the unrepresented, for the overrepresented. So you're targeting the groups that are unrepresented because you do not want the transformation of the judiciary and the executive from being unrepresented and oligarchic to becoming representative and democratic. So the purpose of the real purpose of EWS is an attempt by the oligarchy to prevent the democratic transformation of the Indian state from an oligarchic state to a representative state, by stopping the entry of unrepresented classes, by perpetuating the myth that they're all castes, they're without capacity, without merit, they're incompetent, and their entry into the Indian state or through education to the Indian judiciary and the executive will somehow bring the quality of those institutions down. Actually, your real purpose is you want to maintain a monopolistic, oligarchic control of the judiciary and the executive. That's the real issue here. Those who are excluded are the unrepresented. You have carved out 10% of employment and 10% of education and made it representation proof. In this 10%, there shall be no representation. There shall only be the oligarchy. And so you picked an oligarchy that was described by Mahesh Jethmalani as lower middle class. Attorney General as poorest to the poor, but Mahesh Jethmalani, in an honest moment, advertently or inadvertently referred to them as lower middle class, a group that falls within 96% of the Indian population, which earns less than 25,000 rupees per month for a family of 4. And that's most of the upper caste population. And your explicit purpose is to ensure that 10% of public employment shall be excluded from representation, shall be made representation proof, and shall be peopled only by oligarchs. That's why you said, and why did you, if that was your intention, why did you not say in Article 15.6 and 16.6, instead of providing this very convoluted definition, right? In 15.6 and 16.6 says, nothing in this article shall, any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clauses 4 and 5 of 16 or 4 of and 15. Why did you not say very directly any special provision for the advancement of any economically weaker sections of upper castes? Why did you have to say in a very convoluted way that this applies only to that it is other than the classes in 15.4, 16.4, right? Which it is to hide the truth. You should have said other than unrepresented classes. You should have said in any special provisions for classes that are overrepresented in the judiciary and the state, because 16.4 deals with adequate representation. So you're overriding 16.4. You're saying you have a special provision for those who have more than adequate representation. So you have 16.4 that says give reservation for those who do not have adequate representation. You have 16.6 that says this you shall give reservation for those who are more than adequately represented, subject to a creamy layer cutoff in both cases. That's the truth.
Right, sir.
Now, the dissent understood that. The majority I'm sure, understood that. I don't give them, I mean, they're very brilliant people, but they haven't dealt with this issue.
Also in the judgment, in the majority judgment, two of the judges, they have also, while upholding the EWS reservation, they also made certain observations regarding the need to end reservation within a time span.
Of course, of course.
What are your views regarding that? So
my view is that, see, that is a violation of separation of powers. It is their job is to implement the Constitution within the structure of the Constitution, uphold and protect and secure. That's their oath, that they will uphold the Constitution, right? When the Constitution provides for reservation to bring about a transformation of an oligarchic judiciary, an oligarchic executive, an oligarchic public employment, and oligarchic education to representative and democratic education and public employment, as given that democracy is the ultimate, is one of the ultimate basic features of the Constitution, their job is to advance that goal and to protect that goal. And they are free to say, see, we are not, Mr. Sebastian, we are not here to fight for reservations. We are here to fight for representation. Reservation is a tool for representation. Now reservation is used in EWS as a tool to stop representation by giving representation to the oligarchs. So whatever, if the judges say, look, there is a better way of doing representation than reservation, okay, and or to interpret reservation in such a way as to provide a better, more effective way of representation, then we can accept that. But when they stop at saying that reservation should end, does it mean that oligarchy should continue? Are they saying representation should end? Are they saying democracy should end? When you take away the tool, are you saying therefore the goal should not end? If a car is going to take me from point A to point B, and you take away my car, are you telling me I should not go to point B? Or are you saying I'll take away your car, but I'll give you an airplane to get there faster? In which case I'll say I don't need the car, I'll take the airplane, I'll get there faster. But are you saying no, I don't want you to get to point B? So I think this is we must understand reservation is. I think they have recognized the argument that was made to them that reservation is only a tool. But a tool for representation, a tool which is essential for democracy. And so if you say that, look, this tool is not effective, is not working, here is a better way of getting to that destination, we are not interested in protecting reservation. We are interested only in securing representation. Then we will accept it. But now we've realized that this reservation is an anti-democratic reservation, anti-representation reservation. It is reservation that takes 10% of public employment and 10% of education and makes it permanently non-representative and ensures there is no social representation in that 10%. And it is confined only to the social and educationally forward classes. Is that good for the country? If there's any group that is amongst the upper castes that is socially and educationally backward, they're absolutely, the door is open for them to be classified as socially, educationally backward class and get reservation under 15.4 and 16.4. What is the need to create a separate category for them simply to shut out those who are unrepresented? So let us understand what is going on here is a political battle against democracy by the oligarchy, which is not surprising. I mean, you don't expect the oligarchy to concede their power and their monopoly easily. And so the struggle will continue. But I feel the way forward is we will continue to challenge some of these details in the court, and we will, by making challenges, we know we won't win, but we will be able to hold the state accountable and get them to answer. And if they cannot justify what they're doing, that will be open for the whole, that will become transparent to the whole public, and that will help them to make a decision as to whether this action is right or wrong. But eventually, I think the next step is that all those who are unrepresented, the unrepresented classes, when we say backward, we mean backward in representation. You must read the word backward in the context of 16.4. Those without adequate representation, not those who are less intelligent, less cultured, less capable, but those without representation. So the classes without representation must now unite and mobilize to ensure that starting from 2024, although it may take more time, we must ensure that 2/3 of the parliament will vote to remove from the constitution the 103rd amendment by amendment. That should be the game. Political mobilization to amend the constitution, to remove what is a cancer or in the constitution that will destroy the constitution, not according to me, but according to the 2 dissenting judges, that this will destroy the social fabric of equality. So that's a cancer. It will eat into the social fabric of equality. This cancer has to be surgically removed, not judicially treated, but surgically removed. When treatment fails, when therapy fails, judicial therapy fails, ultimately surgical removal is the only option left. And that surgical removal has to come by getting the unrepresented classes, who are 90% of this country, ensuring that there is a 2/3 majority in parliament that will remove this provision from the constitution. That is the next goal to which I think we must pay attention.
Right, sir. Thank you so much for sharing your strong views on this subject. Thank you so much.
Thank you very much, Mr. Sebastian, for this opportunity. And I must say that I really admire the wonderful work that you do with all your colleagues on LiveLaw. It's a great service to the entire legal profession, I think to the public of this country. It's a very, very valuable service. Thank you for the tremendous effort and tremendous leadership that goes into producing that work.
Thank you so much, sir. Thank you so much.
Thank you. Thank you.